Uh, Good afternoon, everyone. My name is Kanita Williams. Welcome to the Division One's Toolbox Talk Series. I am the chair of the Toolbox Talk Series committee. And basically, the Toolbox Talk Series is just an informal conversation with practitioners in the area of construction law on certain topics. It's only about 30 minutes, and we have it about every 45 to 60 days. Today's discussion will be on considerations for optimizing dispute resolution clauses. And I'm going to let Manuel take it from here and introduce our speakers. If you have any questions, please put those questions in the chat and we'll make sure that we ask the speakers those questions towards the end. I will also be posting the link for the next Toolbox Talk series that will be on May 25th. Go on.
All right, well, thank you, Kanita. Hello, everyone. Thank you for joining us today, especially to our panelists. I'll get to them in just a minute. As Kanita mentioned, my name is Manuel del Valle. I work with Peritia Partners. We're a boutique construction consultancy firm. We provide project management and scheduling services. We also provide expert witness services focused on scheduling, delay and disruption, and standard of care. I'm fairly new to the ABA, as my background has been in the industrial design and construction field for the majority of my career. And just this past year, I joined Peritia to help other contractors when they get into disputes, or even better, to avoid them. I was actually a client of our president for over a decade while working at and later owning an industrial EPC contractor in South America. After going through several dispute resolution processes, I decided I prefer to analyze the cases as a third party than suffer through them as a contractor. I learned that beyond the financial burdens of disputes, they are definitely a huge distraction from the day-to-day operations of a contractor. So today's topic is near and dear to my heart based on past experiences, some positive and some negative. As a contractor, at the front end of an opportunity, you're primarily focused on the strategy to win an opportunity while making sure you cover your project scope, costs, potential risks for execution. You're certainly not focused on potential dispute, that may or may not come several months or years down the road. Only through hindsight do you see the importance of the legal details of a contract, especially the dispute resolution clause. So joining us today are Liza Akins and Sergio Laclau. Liza serves as the Senior Assistant General Counsel and Division Counsel for ARCO Design Build. I believe she's based in Atlanta, Georgia. ARCO is a leading national design construction firm. In her role, Liza is responsible for managing and directly assisting with the negotiation and drafting of construction contracts, as well as managing claims for 18 general contractor offices across the country. She provides valuable guidance to senior stakeholders on legal opportunities and risks, ensuring the company's compliance with industry regulations and best practices. I haven't had the chance to personally work with Liza, but her CEO is an old friend and he speaks highly of her. Also with us today is Sergio Laclau. Hope I got that right, Sergio. First, Sergio, I must apologize for our brochure of today's presentation. Unfortunately, we misspelled your firm's name. It's Mello Torres, no W at the end of Mello, not like Mellow Yellow, it's just Mello without the W. Sergio is the head of dispute resolution practice at Mello Torres Abogados in Sao Paulo, Brazil. He has an LLB and an LLM from the Rio de Janeiro State University and is an LLM candidate at the London School of Economics. He focuses his practice in the area of arbitration, litigation, and international law. Sergio has extensive experience in major domestic and international disputes involving construction, corporate and contractual matters in different industries such as aviation, pharmaceutical, power generation, and distribution, as well as financial services and infrastructure. I had the opportunity to do battle alongside Sergio when he represented my company in an ICC arbitration a few years back. Well, let's get into it. Liza, there are cases where a dispute may be minor, yet the dispute resolution calls for an arbitration with a three arbiter panel, or the contrary, where the dispute is too complicated and in relation to maybe a rudimentary agreement. What are some of the strategies you can implement to avoid this potential misalignment?
It is extremely common that you see these dispute resolution sections that start by just saying, we're definitely going to have a three-person panel for every single dispute. And we try our best to help guide the negotiations so that we get away from that, and typically tend to look for a dollar value for the dispute where we could say until it's $1 million, depends on the size of the contract. For us, $1 million would be a pretty significant dispute. We would prefer to see one arbitrator. Conversely, if it's more than $1 million, you don't just want one person who's sitting there, who knows what they might think. That obviously that line of where that dollar value is going to slide with the project and with, the different parties' comfort with taking risk. But that's probably one of the bigger things that we focus on is, trying to figure out where that line is between, the benefit of not paying for three arbitrators versus the risk of having one person just go rogue on their own. So from a, owner contractor perspective, that tends to be what we look at. As a GC, we have a little more control over the dispute resolution mechanisms for our subcontracts. And so for those, usually we actually try to get a little more creative. We do still want to do arbitration. We think that's the best mechanism to resolve disputes, but we will try to involve for those smaller dollar values where we're, say, $500,000 apart. We'll start with mediation, and then if the mediation reveals that we're within $500,000 of each other, we actually usually have the mediator become an arbitrator and make a decision rather than us go through an arbitration on top of the mediation for what is not actually that significant of a dollar value. So.
Okay, thank you. Sergio, would you like to add anything?
No, I think that's pretty much in line with the procedure, how to draft those clauses. I think, yes, there is this issue to determine the threshold that you will use for determining whether you're going to use one arbitrator or three arbitrators. That's interesting because when discussing with the parties, that's always a struggle because the parties understand the point in terms of reducing the costs. If you have one arbitrator, you are spending basically 1/3 of the cost in the arbitrator fees. Okay, so that's very relevant depending on the size of the dispute. On the other hand, the parties feel that they are giving up something because we have to always bear in mind that an arbitration, it's normally it will not, the decision to be rendered would not be subject to any appeal. Meaning when you have three arbitrators, you have more or less the comfort, more than having the right of appoint the arbitrator itself, which sometimes I think it's not the right issue to look at, is the fact that when you have just a single arbitrator, this guy will control basically the fate of what's going to happen. So when you have two others in the panel, you always have a sort of a control of his decision. So if for whatever reason, one of the arbitrators come up with a kind of a very innovative thesis about the case, you always have the other two there that could look at it, make them reflect about whether it's the right way to go or not. And if they do not agree, try to form a majority against this position. So it's always a tricky issue, but it's important because sometimes depending on the amount of the involved in the dispute, having three arbitrators might hinder you from pursuing your rights. Just to add another important point to consider, it's always to look at when you select the specific arbitral institution, to look at the rules to see if they provide for expedited arbitration. Expedited arbitration reduce the costs, reduce the time. It's a simplified procedure. It's important to look at it and bear in mind whether those rules provide for opt-in expedite arbitration provisions, or if they apply automatically. Because depending on the institution, you have to specifically say in your arbitration clause that you want to adhere to those expedite rules, but for others, you don't. And maybe you might be automatically subject to those rules without even knowing. So that's always interesting to look at it.
Okay,
Also-
okay, great. Oh, sorry.
Well, I was just going to add also for, avoiding spending a lot of time and money for those less, the more minor disputes, as you said. I'm a huge advocate for including, mandatory mediation, and even before then, a mandatory meeting between the senior reps. Sometimes it's a check the box exercise, but I have seen it be very valuable for, the leaders of two companies to get in the room. Yes, they've talked to their teams, that, they believe their teams. At the same time, they sometimes can step back and see the bigger picture and move things to resolution without, quite so much bloodshed. So
Absolutely, absolutely. They certainly look at it with a different mindset than somebody focused on a specific project.
Yeah.
All right, well, sometimes things do get a little more complicated. So Sergio, often on larger projects, there may be multiple parties involved executing, different parts of the scope of work, some under a joint venture, others stand alone, where these can sometimes overlap. You may have a joint venture, but then independently executing one of the joint venture partners, executing part of the project. What are some of the, maybe the perils of using boilerplate dispute resolution clauses, especially where there are multiple parties involved? Maybe you have to worry about parent company guarantees because you're using affiliates, whether in joint ventures or where there are multiple contracts, just as examples.
No, that's a very important point to pay attention at, because normally when you're dealing with very complex projects, those projects are composed of a nexus of contracts. So you have different contracts that cover specific issues of the whole project. And then when a dispute arises, it might be difficult for you to pinpoint the specific contract to which the dispute relates. Actually, it probably relates to all the contracts together. So when you have separate contracts, you risk having separate dispute resolution provisions in those agreements. So that's a very important point of tension. You have to avoid that at all costs. If the agreements are just pieces of a same transaction, it's very important that the dispute resolution provisions among them are consistent. And by consistency, I normally mean something very simple. The provisions should be basically the same. It should be the same. So because it's always a problem, not to mention the situations in which you have one agreement of the whole project that is subject to court resolution and others that are subject to arbitration. It's a mess, because that's the key for you having a dispute on jurisdiction right from the start. And there's always one of the parties that might be recalcitrant in terms of fulfilling its obligations under the agreement, and use that to stall dispute and buy time, and even force you to a settlement that you would otherwise not be intending to enter into. So you have to look first from a formal point that the provisions look the same. They are basically the same. It's important. Don't try to incorporate provision by reference. It is valid. Yes, it may be, but it's also a point that might render discussion, depending on how you reference the dispute resolution provision of another agreement. It's better to kind of replicate the provision in your agreement with the same institution, same number of traders, same seat, same language, governing law, everything. And on the top of that, it's important to negotiate a provision that allows you to consolidate claims in case it happens that you start a dispute under one agreement and the other part decides to start a parallel dispute on the basis of another agreement. So it's important that the provisions have both agreements have a consolidation clause that allows you to consolidate at very early those cases so that they can be decided all together. So I think that's a key point. And just to add from a subjective perspective, arbitration is a creature of an agreement. So parties are only bound to arbitration if they, in the first place, agreed to arbitrate. So it's very important that you make sure that all the parties that are relevant to your transaction have agreed to the arbitration provision that you have in your agreement. For instance, if you have a parent company guarantee, or if you have it's very common in construction agreements that have a special purpose company that it's incorporated just for carrying on the works, but it has no assets at all. So if you don't have access to the parent company, if you don't have it signing the arbitration agreement, agreeing to it, you might find yourself in a situation in which you have only recourse in arbitration against the special purpose company and might not attract the parent company inside dispute. Yes, there are lots of theories that you can do that, even in case that part has not signed an agreement. But once again, that's a separate dispute that you're gonna start and lose time and lose money. So forget the theory. The theory is to apply when you have forgotten to include the provision. So include that in the first place to save some time and resources.
Okay. Well, you know, not all disputes arise from large and complicated multi-party projects. You know, often they come from routine type of construction projects. Listen, I always love getting the perspective of an in-house, especially in your case, because you kind of have to deal with both sides. You deal with owners as a GC, and then you also have to look at it from a GC to a subcontractor perspective. So that may change the way you want to, you know, control or tweak that clause. We kind of always start with the boilerplate, but when getting away from boilerplate clauses, or maybe trying to streamline a potential dispute, so I think you touched on, what are some of the alternative methods or creative ideas that you've tried out, and how have they worked out?
Yeah, so you know, I mentioned this before with our subcontracts, we've implemented a mediation arbitration system. So we're huge proponents of mediation. We think it's a great way to go ahead and get, you know, something resolved so that, you know, I probably both parties walk away equally unhappy, but they're willing to, you know, accept the bitter pill. But, you know, that doesn't always work out. With our subcontracts, we can have disputes that are as small as $10,000, but we're still having to take that all the way. You know, the types of projects that we do are, you know, on such small margins that's still a significant, you know, value to our project teams. And so, you know, we found that we were often going to arbitration and spending a significant amount on attorney's fees and the arbitrator for small dollar values. And so instead, we implemented a system where once you've done the mediation, you're getting towards the end of the day, both parties submit what, you know, sort of their last offer. And assuming that those offers are not accepted, you know, on either side by the other party, if the offers are within $500,000 of each other, instead of us then walking away, preparing for an arbitration, having to go through that whole process, instead the mediator becomes an arbitrator. So just using, you know, what is the publicly available knowledge that was provided to the other side as well. The mediator looks at the two offers, and it's a baseball arbitration at that point. He or she chooses one of those two offers, and that's the end of it. We walk away and we've got a resolution, and sometimes it's in our favor, sometimes it's not. But we've found that we're happier knowing that we didn't spend a ton of time and a ton of money getting to that point. even if it means that we're, having to pay when we don't believe we have to. So for us, that's been a huge asset in getting things resolved. Some of our subcontractors love it. They also don't want to spend a lot of time and money on things. There are some that, wish that they could really take things to the mat, but ultimately, those are usually the subs we don't plan on working with again. So it works out.
Okay, no, I understand. It sometimes it's a measure of pride versus financial reality.
Right.
Just a little interjection. I've had both good and bad experiences due to dispute clauses. Just a couple quick examples. Some time back, my company was serving as a contractor for a Russian company who was financing a project in Ecuador to build a power plant for the state. After the relationship between the developer and the state went sideways, we were left in limbo on the project as a contractor. The developer then came back and requested a refund of our advance payment while holding back progress payments. When we refused, basically due to lack of payment, they wanted to initiate a dispute. However, because of the way the dispute clause was written, it was just simply not enforceable. It just didn't make sense. And of course, nobody realized that up front. In the end, that worked out well for us. On the other hand, the dispute, another dispute, which Sergio is intimately familiar with, we had one that involved a Uruguayan owner. There was an Asian EPC contractor and us, the South American construction company. We both had foreign companies with local entities in Uruguay working on a large industrial project. When the dispute began, there was a conflict of jurisdiction. And I think, Sergio, you touched on this a little bit before. And it was a conflict between the local courts and the ICC, and the way the clause was written compared to the law that was the basis of the clause in Uruguay. They just didn't quite coincide. But it was a mess at the end of the day. And we ended up spending 1.5 to 2 years just to establish jurisdiction for the dispute. That time as an owner, this was crushing. Because our client was, of course, holding progress payments. He had called and collected our bank guarantee, and on top of that, caused us to spend millions of dollars during the dispute process, which ultimately lasted almost 5 years. And as I mentioned, Sergio knows this case pretty well. So, Sergio, how can some of these complex issues, especially when you're dealing with different laws or maybe different implementation of the law because of the clause or the venue, how can these be avoided? Or maybe they can't be avoided, but at least they can be mitigated. What are some of the issues we need to look out for up front, regarding whether it's the resolution seat, the law, the location, what should be considered?
I think, the first point, as I mentioned before, you should pay attention that the parties that you need to involve in the arbitration procedure, they are bound to your arbitration, to your agreement to arbitrate. So they have to sign it. Either the main contract or whatever other document they sign might have a similar provision binding them to arbitration, because that's a problem. Sometimes we have to reach a party that has simply not expressly agreed to the arbitration provision. That's one point. The second, it's always looking for a more objective perspective, to have a very broad terms in your provision in terms of the disputes that are covered. Saying that, it's all the disputes arising from or in connection with or related to the agreement are subject to be decided upon arbitration, to avoid discussions that you have a restricted scope and not everything you agree to arbitrate, because that's another source of disputes in terms of jurisdiction. Thirdly, I'll say that it's important to have proper counsel in selecting a venue in a jurisdiction that's arbitration friendly. That's sometimes an issue that parties do not pay much attention. I have been involved. That's a real case, international project in which the parties said, well, the contractor was from one specific jurisdiction, the employer from a different one, so they agreed that the seat could not be in neither of their jurisdictions. So how are we gonna select what they call a neutral jurisdiction? Well, they just open up a map, and well, this country here seems better position in terms of the cost, is not so far from you, not so far from me. That's wrong. You don't do like this, because this way, okay, you might save a few bucks in air tickets and hotels, but you're gonna spend a lot trying to fight a local courts that might feel that they have under local law the right to intervene in your arbitration, to decide beforehand whether they have whether disputes should be subject to arbitration or not. So that's critical, and you have indexes of that define jurisdictions that are friendlier or not to arbitration. That's something that we should always look at. In terms of governing law, sometimes there's lots of disputes on whether the governing law that you selected to your agreement, the substantive law of the agreement, would also automatically be the applicable law to the arbitration procedure, or whether the arbitration procedure would be subject to the law of the country that you selected as venue. Those rules are not always clear. Depending on the jurisdiction, there are different interpretations of it. So to avoid any future dispute on that, it's always advisable as well to determine which law you understand is applicable to arbitration procedure itself, even if it's the same law of the main agreement or the law of the venue. That should be seen on a case-by-case situation.
Thanks, sir. Yeah, I know in some cases they wanted us to go out to Singapore from South America for arbitrations, and you know there's no midpoint there. So we usually settle somewhere in the U.S. or something. But unfortunately, I think we're running short on time, so can't ask you all any more questions. So let me turn it back to Kanita and see if we had any questions.
Yes, so we have one question in the chat. Thank you, Patricia. To our guest speakers, and you, Manuel, too. What do you think about agreeing to one arbitrator, but preserve the right to a private appeal, which you can do by contract, so you have a remedy for the fear of the sole rogue arbitrator?
I may jump in. I think, well, first of all, there are different ways to understand what's right to appeal. Does it mean going to a court of law? Does it mean having a second arbitration? I would not recommend neither of those alternatives. Going to a court as an appeal, if you're not satisfied with the decision, means that the whole time that you lost, that you spent in the case is lost, because the whole procedure is going to be revised by a court of law that may reach different conclusions and follow different procedures. Just because they follow different procedures, for instance, having a second arbitration, you are agreeing beforehand that you're going to have two procedures in sequence, because you never know which will be the outcome. It will be you may feel it's a horrible decision because you lost, the other party is happy, and vice versa. So basically, we're agreeing to have two arbitrations in sequence. So the money that you're going to expend in those two procedures is probably more than having three arbitrators beforehand. So if you feel insecure with one, go with three instead of having this appeal mechanism.
Yeah, I from an owner perspective, I would agree. You know, like I said, some go well, some go bad. Usually at the end of the day, you end up with a bad taste in your mouth regardless. And the biggest impact on a contractor is the distraction from the day-to-day operation. You know, so at the end of the day, if it's a little more, a little less cost, fine, you know, better than having to go through the process twice. I think the time aspect is where I would lean into to say, let's go through this once, and good or bad, let's put it behind us and move on.
Yes, I agree. I mean, part of the reason we like arbitration, excuse me, in the first place, in addition to being able to have, construction law experts be the decision makers, is the speed. I mean, especially these days, litigation, our litigations are dragging on, years longer than they normally would because the courts are so backed up. So, we choose arbitration in part because of the speed and having that finality. And so, I don't think we'd want that, appeals process. I'd much rather just go with my 3 arbitrators and, put my faith in that.
All right. Well, thanks for the question, Patricia.
Yes,
you're
that was the
welcome.
only question. It was a good
I'm-
question.
I'm happy to tell you that it can be done very quickly, very inexpensively, and it's not a whole new arbitration, but that's for a different day.
Okay.
Might be another
Okay.
interesting topic.
Hey, there you go.
So I have put a link in the chat box for everyone to register for the May 25th Toolbox Talk series. So I hope you guys will go ahead and register, and I hope to be seeing you all again. And thank you for spending your part of your lunch with us. Okay. Bye, everyone.
Yes. Thank you, Liza and Sergio, for
Yes.
taking your time.
Thank you so much.
See you all at the next
Mhm.